Hello, my name is Alet Ace. I'm a practicing attorney in Pretoria, South Africa, and this is the second episode of Lunch Hour Law. Lunch Hour Law is an informal legal discussion to try and assist South Africans with real life issues. It's by no means academic, so please do not see this as a legal lecture, and it's also by no means everything that can be said about a topic. It's something that has come up in my legal practice recently and that I thought would be able to assist more people. Therefore, I'm speaking today about the POPI Act. POPI Act is a very, very new act. It was formally and completely implemented on the 1st of July 2021. So it's a little bit more than 3 weeks old, which is brand new. What does that mean for legal practitioners? For us, it means we're not completely sure how courts will deal with this act and the implementation thereof in a legal practice sense yet. What I can say, however, is be sure that you look at this act. It's not something that comes and goes, that's sort of nice to have. If you have a business or you're an individual doing any sort of business or getting in an income where you work with any sort of personal information, you need to look at this act. It's not just for legal people, so to speak. Right. So what is POPI Act? POPI Act officially is the Protection of Personal Information Act. It's almost 150 pages long, which makes it not a very short act, which also gives you an idea that I would by no means discuss the entire act in this episode, of course. So this is just like basics, right? For the sake of getting the most out of this episode, I thought I would once again use a real life example. So for the sake of this, let's say you are a person that installs fencing for a living and you have various clients and customers on your books. Someone phones you and asks you to come to their business premises to come and install a new fence. So what is the first thing that you maybe do? You send them a form asking for their address of this business residence, asking who would be liable for the account, asking maybe a bit more personal information about the business or about the director of this business. Via asking for all of that in the normal and ordinary course of your business, you are already what we call processing personal information. What does that mean? It means that the POPI Act will apply to you and to your fencing business. It's nothing foreign, it's nothing that you can ignore, you have to look at it. So the best way of looking at it is possibly to consult a formal attorney. So bargain with an attorney, ask them whether they can maybe come down with their tariffs a little bit. And the reason for my saying that it may be good to employ the formal services of a legal practitioner is every business or individual that processes personal information should have an information policy. It's no easy feat to draft an information policy as it should be in compliance of all 150 pages of the POPI Act. So even for an experienced civil law attorney, it's still quite new and it's still quite challenging. So for you with possibly no legal background, please try and consult a legal practitioner. Right, back to the fencing business example. You've now collected personal information or processed personal information by asking your new customer for a lot of their information, such as their address, etc. The term personal information is a very extensively defined or wide term. And the POPI Act has a very good definitions clause setting out what personal information entails. I'll just read a few examples. Address, telephone number, email address, history of education, history of employment, pregnancy, marital status, sexual orientation, age, health. Any of those factors would be considered as you processing, working with, collecting or storing personal information, right? One of the particular sections I would like to look at for purposes of really superficially looking at the POPI Act and what your information policy would typically look at is Section 5. Section 5 has various subsections. Some of them deal with how you should notify your client, customer, or as the Act refers to it, your data subject. And some of the aspects refer to direct marketing, which is for most South Africans quite a pain because those are the typical spam SMSs, spam emails, etc. Right. So briefly looking at the data subjects rights. When you collect or process or work with a business or individual's personal information, you should, in terms of Section 5, notify that data subject, or for purposes of this discussion, your customer or client, notify them as to why you are collecting that personal information, what you're going to do with it, who will be responsible at your business for looking after the safekeeping of that information, etc., etc. So there's a definite notification obligation on you. You cannot just send out your form to say, fill in your personal information for us to install the fence. You need to do more than that. You need to indicate how you're going to go about protecting and safekeeping of that personal information and the particular purpose for asking personal information. So every single line on your new client, new patient, new customer form should have a reason. We cannot just ask personal information for the sake of anymore. We need to justify why. The other thing that is important to note in terms of notification is if you have had a security compromise, in other words, someone has hacked, for example, your business and stolen or unduly obtained personal information, you have an obligation to inform or notify the data subject to whom that information relates, as well as the information regulator. The information regulator is also quite a new role, which is now obviously established in terms of the POPI Act. That officer's role and powers are fully explained very well in this POPI Act, and the information regulator will also do a function in terms of the Promotion of Access to Information Act, the POPI Act, which is an older and a different information type of act. So you know someone has hacked your business. They may or may not have obtained access to certain of your fencing customers' personal information. You need to send out an email from your office to those people saying, this is unfortunate, this has happened, there has been a cyber attack, your personal information may have been leaked. And even more than just notifying them, you need to explain to them how you're going to protect them from the consequences of the cyber attack or hack. So this is all just Section 5A. So just to give you an idea of how extensive the protection of personal information is, this is just a subsection of one section, as an example. The other thing that I want to speak about in terms of Section 5 for this fencing business is direct marketing, right? So direct marketing, and I will read from Section 5E, is the following. It is to use someone's personal information to market to him or her directly per email, SMS, fax, or automatic calling machines. Worth noting, normal telephone calls that are not automatic calling machines are still allowed. So the cold calls that you get are technically still allowed even under this POPI Act, which some would say is unfortunate. The idea is, however, that you cannot just be part of someone's database where they spam you on a regular basis with marketing. So you, under your fencing business, should take absolute cognizance of this and be responsible and not use existing or new clients' personal information to send them through direct marketing that they do not consent to. So the obvious exception to this is if someone consents. But in general, do not use personal information for direct marketing via any of these methods that I've just mentioned. Right, so what happens, for example, if you do not comply with these two very random subsections that I've chosen, or any of the other 12 chapters and 150 pages of the POPI Act? Well, there can be very dire and extensive consequences. And this is why I say it is worth noting for every business, individual, professional person, etc., working with personal information, that they should comply with the POPI Act. One of the things that could happen in consequence of non-compliance is in terms of Section 5H, which is to complain to the information regulator, and the information regulator, as I've said, has certain powers to make certain findings or awards under the POPI Act. The other possible consequence that concerns me more and is more striking to me is that one may actually claim civil damages under Section 5I of the POPI Act if someone does not comply with this act. Civil damages meaning in this instance, and I'll read again, could be patrimonial or non-patrimonial damage, interest and legal costs. So any of the typical aspects which one may see claimed in terms of civil law in any other context may also be claimed in context of a breach of personal information. So that's a very wide sort of bunch of types of damage for someone to choose from, to claim from you. If you, from your fencing business aside, do not fully comply, right? What is also interesting for, in terms of civil damages to me, is that a court will be guided by what is considered just and equitable. Now, in general, just and equitable, it has different meanings under different types of and areas of law, but in general, I would say that means a court has a very wide discretion as to the type and the amount of civil damages that could possibly be awarded under the POPI Act, right? Coming back to the fencing business, what do we do first? If you do not have any idea what you're doing with the POPI Act, consider the assistance of a legal practitioner. Consider it anyway because it's new and therefore it's difficult to navigate this. If you do not want to consult an attorney, you could possibly try and navigate the POPI Act yourself and try and transform that into what you should have, which is an information policy. Your information policy should be rotated and sent to all your employees or persons in your business that are in any way involved with dealing with this personal information in respect of your clients, right? The other thing that you should do as a fencing business is every time you ask for new personal information, you should notify as to why, who will be responsible for looking after that on your side, what is the purpose of each of those aspects of personal information, etc., etc. So we have that notification or positive duty on you to notify your client as to why you're asking for certain information. The other thing that is also worth noting, I think, as a very basic thing under POPI Act, is an information officer, internal or external, but representative of your fencing business should be appointed. The information officer is the person responsible for looking after the personal information and is also the person responsible for liaising with the information regulator in instances where, for example, there was a compromise. Speaking of compromises, the South African company Accenture has actually stated at some stage that South Africa has the third most cyber attacks in the world and that billions of rands are lost every year based on cyber attacks and breaches of personal information. So it is a real problem. It is interesting to note also that South Africa may be said to be a little bit behind the curve with POPI. We are 5 years plus minus after the European Union's GDPR, or General Data Protection Regulation, which is considered the most strict protection of personal data or personal information act in the world. So we're trying to follow suit to say we have to also be responsible for managing and looking after personal data in the right manner. There's a whole component that will not be discussed at all in here, which I think is worth mentioning in brief, and that is you should really look at your IT systems. Do you have proper antivirus? Do you have, if you are storing everything on a cloud, is the cloud protected? So it's worth getting someone in the IT world involved just to look at your things, to test very simply whether or not you comply with very basic and general standards. Right, so that is Protection of Personal Information Act in the smallest nutshell that one could possibly discuss it in. I've basically touched on one or two subsections of a section of the entire Act to illustrate how important it is that you really look at this at some point and sit down and as you would sit down and look at your books for the year or sit down and talk with your financial people or other people, you need to sit down and really talk about personal information and how you are going to comply. I will put up the information in respect of the information regulator of South Africa in a separate slide at the end of this, and I hope to upload a brand new episode on a different topic very soon. this concludes a very short lunch hour version of POPI Act to maybe serve as a wake-up call. I hope that you have enjoyed it. I hope that you have received some sort of information you didn't have before, and I hope that you will subscribe to Lunch Hour Law and stay tuned for our next episodes. Have a lovely weekend. Please keep safe with COVID-19 and see you soon. Bye.
We both know it's too late, but I think you already know. 'Cause it shows that every time you're around I try